Out of breath.
All right, sir, you Marshall Chance. And Mr. Chance is here in cause number 26 DCCR 0370 and charged with aggravated assault with a deadly weapon. Mr. Gertz is the attorney. Mr. Eckhart's here for Mr. Gertz today and has filed a motion asking that I consider removing the GPS monitoring device because you're unable to get on the premises of work. Is that correct? There's an issue?
Yes, Judge. So since he's been on bond conditions, he's been on short-term leave. He is now in the process of trying to get back to work, and the facility will not let him work where he does, where his normal job duties require because he works around explosives. The GPS company, they've gone through efforts to see if the GPS company can verify the equipment as it's an industry term, intrinsically safe, meaning that it can withstand any elements that would potentially cause ignitable liquids to explode. So I think there's a lot of devices that cannot go into certain facilities because they are not deemed intrinsically safe, like cell phones and things like that. And the GPS monitoring company cannot verify that. So we're kind of at an impasse where he's either going to lose his job or we're going to have to figure out another way to monitor him.
All right, and just for the record, I am taking judicial notice of the court's file, review the probable cause affidavit as well, and that underlying offense. Mr. Smith, what's the state's position?
I don't, and I understand where they're coming from, and I guess I don't have much of a position.
And Judge, just for the
Person might lose their job.
right, just for the court's.
Well, I mean, I would too. However, there's obviously the allegations are very serious. Has there been any issue that you know of? Have you heard from the complaining witness?
Not that I've heard from, and not that I know of, Judge.
So here's what I want to do. I would like for you to get in touch with her prior to me ruling on this. And what I can do is we don't necessarily, if there's no issues with her and any contact, put it in an email between myself and you and Mr. Gertz, and I can make a ruling without having to come back to court. And I can do that a little quicker since we don't have a docket next Monday. If there is an issue, then obviously if we need to come back, we'll reset it just for a couple of weeks and come back and let everybody make that argument or bring her here or whatever we need to do. Okay. All right. So stay in touch with Mr. Gertz. He'll be getting an email and we'll figure that out if there's any issues, and then I'll make a will for that. Okay.
Thank you, Judge.
Yes, sir. Looks like okay, so you're John Martin.
Yes, ma'am.
It's Miss Malfino's. John Martin.
Recognize the name, sorry.
Just 25 DCCR 0583. Mr. Martin's charged with injury to a child, elderly, or disabled. It looks like I have a notation that he was going to need to go get a 10 print done at the jail. Did you get that done? Huh? A what? A what? I don't know. I have a notation on my docket.
Be permit
Huh?
for the TRN with,
Did he bond out of another jail or something?
he hasn't even played this game.
No, it's not for a plea. It's because there was an issue, I guess, at the jail with
What's your middle name?
John Martin. Are you John Martin?
Yes, yes. Yes.
Right, in DPS, I don't know, something happened at the jail, it didn't happen right.
Okay.
To have an accurate TRN, it needs to be.
It's just he goes and he does it and he leaves. It's not going in.
He
Do
can,
they know that
he needs to speak with Latonia.
if you could? This is the first I've known about a judgment.
Well, I don't understand. Okay, never mind. Maybe was just because that came up between, okay. So what we need you to do, it looks like there was an issue when you were in jail getting the prints done right and the number assigned to your case through DPS. So I'm going to order you between now and that next court date to go to the jail. It's probably best if you go, not probably best, you need to go during working hours so that you can ask for that person. Miss Werner will make sure that she knows you're coming. It'd be great if you would go get it done today, possibly go straight there, get it over with. So that we don't have any issues. We've got to get that done before we can do anything else, okay?
Okay.
So you'll just go to,
Then let me know that you've done it. So I
he needs to go to releases, I guess, and go in through that door. You'll go in through the releases door. You can explain where y'all go through, Mr. Burbank,
go to the window and say, I need to see this.
to do it, just to do my fingerprints.
Flat came out of the one next door.
Hmm.
No, but where you came out of,
Where you came out.
go back in.
And there's a window right there.
Okay.
Where you came out, go into that door, go to that window and tell them that or that you have to go do your 10 print and ask for her and they'll know what you need to do. Okay, and they'll just get your fingerprints done and you'll be able to leave. Okay, nobody's gonna keep you there or anything.
Already. Okay.
Okay, so now, but so what is the actual announcement though?
Yeah, we something was yes.
Got the records, Judge, they were not separated, they were redacted,
Right,
and they were sent to me.
right. You've sent them to
Unredacted
everybody.
and redacted.
Yeah,
At your instruction, I sent you the thumb drive with the originals. I did not open them, and I provided Mr. Burbank myself a copy of the redacted.
right.
And that's what we.
And I'm going through it right now, Judge.
Okay.
And so I just asked for.
So this will be the last reset. We waited a while on those. And so now that we have that, let's get done, reset it one more time. Let's get an announcement at the next court date and make sure you go get those fingerprints done. Okay.
Okay.
All right. You're free to go, sir.
So,
And then you have Crystal Robertson.
yes, sir.
This is Mr. Okay, thank you. Good morning, ma'am. Are you Crystal Robertson? This is 25 DCCR 1526. Ms. Robertson's charged with forgery of a governmental instrument. And what is the announcement?
Ask for one more reset, Judge. This is a restitution case. Unbeknownst to me, she's paying restitution to the bank right now.
Okay,
And so it's just a money thing.
figuring out how, okay.
And so, and then it all will be,
All right, we'll just do a normal reset, and then we'll see where we are at that.
and she is making payments to get this matter taken.
Okay.
But it's also trying to get money to get it over.
Okay, sounds good. Stay in touch with Mr. Burbank. He'll let you know when your next court date is. You're free to go. And then I'm holding, Chandler. Or did
Yeah.
we end up taking care of? Good morning, sir. Are you Richard Couch? Speak up, please. And will your client waive the formal reading of the indictment?
Yes, Your Honor. Sorry about the fold.
That's okay. See, Mr. Couch, in cause number 26 DCCR 0142, you're charged with a third-degree felony offense of driving while intoxicated with previous convictions from December 8th of 2025. The indictment alleges you were previously convicted of driving while intoxicated December 2nd of 2013. And after that was final, you were convicted of driving while intoxicated March 22nd of 2018. And how do you plead to that charge?
Oh.
And are those prior DWI convictions true?
Yes.
I have here on, are you pleading guilty and true freely and voluntarily?
Yes.
And because you did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Wilkerson?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like you guys have agreed to at least underlying a 10-year term in prison that would be probated. There would be a $1,500 fine, the required 10 days in jail and other conditions. But as far as the length of probation, you're leaving that up to the court. You're asking for 5 years, you're asking for 10 years. Is that what you understand as the agreement?
There is, as part of those standard DWI terms and conditions for a third ignition. Yeah.
Right. Everything that would be a regular condition as well. So really the only thing that's not agreed upon is the length of the probation, correct?
Correct.
All right. Do you also understand, sir, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenors number 1.
No objection.
It's admitted. Is there any evidence that Mr. Couch is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right, we'll see you back at sentencing. Thank you.
Thank you, Your Honor. Be excused.
Yes, sir.